This California regulatory explainer is on the economic impact analysis that's done for proposed regulations. As part of California's Administrative Procedure Act, or APA, which is found in the California Government Code, executive branch agencies and departments that adopt regulations are required to conduct an economic impact analysis on those proposed regulatory changes. So, what is this analysis and how have the courts interpreted agency actions to comply with this statutory mandate? Well, under existing state law, all regulations are required to have an analysis of the potential economic impact of a proposed regulation. Specifically, under Government Code Section 11346.3, a state entity proposing to adopt, amend, or repeal any regulation is required to assess the potential for adverse economic impact on California business enterprises and individuals. So these rulemaking entities are required to avoid the imposition of unnecessary or unreasonable regulations or reporting, record keeping, or compliance requirements imposed on business enterprises and individuals. This short economic analysis is done by completing what's called the Economic Impact Statement, or EIS, which is basically a 5-page fill in the blanks type form, and it's probably sufficient for most regulations. Now, a state entity, prior to submitting its proposed regulatory actions to California's Office of Administrative Law, or OAL, which begins the formal rulemaking process, it must consider the proposal's impact on business with consideration of industries affected, including the ability of California businesses to compete with businesses in other states. The state rulemaking entity must even consider information that's supplied by interested parties. What does this economic assessment include? The state regulatory entity is required to assess whether and to what extent the proposed regulatory changes will affect the following. First, the creation or elimination of jobs within the state. Second, the creation of new businesses or the elimination of existing businesses in this state. The expansion of businesses currently doing business in the state. And fourth, the benefits of the regulation to the health and welfare of California residents, worker safety, and the state's environment. Under California's APA, an economic impact assessment of a proposed regulation has 3 phases. In the first phase, the agency makes an initial provisional determination of whether the proposed rule will have a significant adverse economic impact on businesses. In the second phase, during the public comment period, affected parties may comment on the agency's initial determination and supply additional information that's relevant to the issue. In the third phase, when the agency issues its final decision and its statement of reasons, the agency must respond to the public comments and either change its proposal in response to the comments or explain why it has not done so. And this was reiterated by the California Supreme Court in its 2013 decision of Western States Petroleum Association versus the State Board of Equalization. In the California Appellate Court decision in 2018 of John R. Lawson Rock and Oil versus State Air Resources Board, the appellate court said that under the economic impact assessment requirement of the state's APA, a rulemaking agency making an initial disclosure must include the facts, evidence, documents, or testimony that's been relied on to support an initial determination that the regulatory action being proposed will not have a significant adverse economic impact on business. In that case, they also said that the APA broadly requires consideration of significant statewide adverse economic impacts that are directly affecting business and the APA. And the APA, in fact, requires an economic analysis of several factors that are broadly drafted in a manner which does not suggest solely interstate impacts. The appellate court also said that a rulemaking agency is not permitted under the statutory scheme contained in the APA to ignore evidence of impacts to specific segments of businesses that are already doing business in this state from benefits to other in-state businesses when proceeding under the provisions of the APA. And finally, in the Court of Appeal decision in 2011, California Association of Medical Product Suppliers versus Maxwell Jolly, the appeals court said that the agency's determination does not need to be conclusive. The agency need not assess or declare all adverse economic impacts anticipated. An agency's initial determination of the economic impact of a regulation being proposed under the APA calls for an evaluation based on facts. Mere speculative belief is not sufficient to support an agency declaration of its initial determination about the potential economic impact of a regulation under the APA, and the agency must provide in the record any facts, evidence, documents, testimony, or other evidence upon which it relies for its initial determination regarding the economic impact of its proposed regulatory activities.